Been there, done that. Anyway, it's great to be here. Welcome to our seminar. There's a certain irony about this talk and the previous one, in that we had a lawyer talking at length, considerable length, about IT, and I'm an IT person, and I'm going to talk about the law. I hope I'm as successful. Okay, that's an opening statement. I came across it recently. I really like the succinctness of that. I'm sure there are some who may disagree, but I like that idea. And this, of course, is a statement by Plato, talking about law. Good men do not require laws, and bad men will not obey them. So, this talk is based on this book, The Enterprise of Law, written by Bruce Benson, published in 1990. It's quite old. I'd like to thank George Werner, who lent me his copy of the book, which he actually got from Nancy Sejas, which now Nancy Vermeulen, which I think many of the older libertarians will remember. And to my surprise, I found out that this presentation on this book has already been given by Nancy, but I doubt whether many of you actually would remember that particular presentation way back in the 1990s. So the central thesis of the talk is that you don't need a judiciary or a police force or even a state to ensure justice, safety, and fairness, but you do need a plan. So I'm an anarchist. There's a couple of us in here, I presume. Haven't thrown any bombs recently, but this is as close as I suppose as I've got to anarchy in the recent past. And I believe that voluntary cooperative institutions can create an ordered and humane society without powerful leaders and state enforcement mechanisms. That's what I believe, but I'm not a lawyer. Now, many libertarians are minarchists who believe that the requirement, the need for a judiciary justifies the existence of a minimal night watchman, perhaps, state. And I would contend that is an excuse we do not need to entertain. We can, in fact, do without the whole structure. Now, many libertarians are lawyers. I'm afraid I am definitely not a lawyer, and I'm fairly sure this talk will annoy most of them. But that is perhaps the intention. So how did the English and American systems of justice arise, what we might call our Western civilization? Where did it really begin? What is its origin? And this came as a surprise to me. Even though I'd watched Vikings, I did not realize that this was really the basis of how we got to where we are today. So after the fall of Rome in about 500, Anglo-Saxon customary law prevailed in England for 500 years. That's twice the length of time of the American experiment at this point in time. And as Hayek often says, is if something survives for a long time, no matter how long, it must have some intrinsic value, at least to the society in which it survives. Otherwise, it would not survive. The Normans came along in 1066 and effectively swept away the Anglo-Saxon customary law. And from then on, a very severe king-based state and a king-based law developed, with some relief being obtained in 1215 via Magna Carta. But nevertheless, to this day, state law developed by kings, clergy, and the aristocracy has supplanted customary law right up to the current time. I must perhaps explain that term customary law. It was a new term for me. I'd be curious to know whether it's a term well known to the lawyers in the room. But I would have confused it with common law, but it is profoundly different to common law. Customary law is the law effectively of the people in small tribes, in smaller kingdoms. It's similar to the customary law that our black tribes in this country would practice and would wish to practice. The Americans still considered law to be a function of the state, even after their revolution. They never really went in the customary law direction. And a lot of what I'm going to talk about is going to be about customary law and its characteristics. And as I say, don't confuse it with common law, where common law is basically state law, king-made law, written down and passed on, with many good features, habeas corpus, trial by jury, etc., but it's not the same as customary law. So customary law requires widespread community acceptance. You can impose state law anytime you like, if you have a big enough army. It doesn't depend on any sense of community acceptance. Within customary law, each individual must recognize the benefit of behaving as others expect, and given that he or she will behave as expected. In other words, there's this real quid pro quo. If I come into your restaurant, for example, I'm entitled to expect a certain level of service, and you're entitled to expect a certain level of payment. Whether that's customary law, common law, state law, nevertheless, there is a sense of reciprocity that is critical to the idea of customary law. Great thing about customary law is it requires less enforcement, since observance is largely voluntary. Certainly state law will be enforced. There is nothing voluntary about your acquiescence to state law. And as I said, it depends on a sense of reciprocity amongst citizens. And the interesting thing, and I'll quote a range of examples of customary law from around the world, always private property and individual rights are paramount. You know, we may think of libertarianism as an invention of the 17th and 18th century, but the elements of it have been around for a lot longer. And the whole purpose of customary law is to regulate individual interactions. So when one talks about a sense of reciprocity, it's basically, I'll pick the fleas off your back if I can expect we'll all turn around and you'll start picking the fleas off my back in the near future. There's a reciprocity about our interactions. The key thing is that customary law arises as a spontaneous order. Just like the market arises as a spontaneous order, language arises as a spontaneous order. There's no leader, nobody even writing down the rules. Customary law is another spontaneously evolving event. And successful individual agreements within a particular area, within a tribe, will spread to other members of the group over time and will become essentially the basis of an observed law within a particular community and perhaps in a wider community. There's no guarantee that the same law will be observed in different or neighboring communities. The rights become defined when the benefits of doing so exceeds the costs. So there is nobody in charge writing down the law, ensuring that it gets passed out amongst the population. But if it seems worthwhile, people misunderstand your rights when entering an ale house or something along those lines, well, then that law may well become written down. And as Hayek and others would say, is that good rules that facilitate peaceful interaction will drive out bad rules over time. So Anglo-Saxon law, prior to the Norman invasion, had the characteristics of a primitive legal system. It's not a sophisticated legal system. It doesn't have 5,000 law books in a bookcase. But it was very concerned with the protection of individuals and their property. And of course, it would have been, because this law is being created, essentially, by individuals, mostly to protect their property. Key point is that in customary law, the focus is on restitution, conflict avoidance, local solutions, and cost reduction. These are all good things that are of no interest, by and large, to state law. And by state law, well, we'll explain that in more detail in a few moments. But it's really important to grasp this difference between a law that favors restitution to the victim as opposed to a law that favors punishment of the aggressor, but no restitution to the victim at all. So, the first question, which I'm sure one would ask is, well, we have a dispute in the tribe, we have a dispute in the libertarian environment, we have a dispute in Velddrif. How are we going to resolve those disputes if we can't get on the line and call up the local police station and have them come down here and sort out the trouble? So no single coercive authority within customary law exists to force the disputants into court. Within state law, yep, the police show up, they throw you in jail, they hold you over until they get you to court. But within customary law, you steal my iPhone, and if it's no big deal to me, essentially nothing happens. There's no coercive authority to say that, well, a theft has taken place, it must be resolved. I must, as the aggrieved party, agree to and understand that I must pursue the prosecution, alone or with assistance. And this ability to obtain support in order to pursue aggrieved losses such as theft, this ability depends on reciprocal loyalties previously established and honored. In other words, within the community, I must have a group of friends, a group of family, people who know me and like me enough to say, whoa, you've just been robbed. We'll join with you, we'll go around to the robber's house, and we'll get that darn iPhone back. What is most likely to happen, of course, though, is that I will have established a previous arrangement with some kind of security agency, some enforcement agency, who, for a monthly fee, will undertake the pursuit of wrongdoers for prosecution. And I believe, and it has certainly been observed in other societies, that due to the high cost of conflict, non-violent dispute mechanisms quickly arise. And there's many places you can see this in action all over the world. It's much cheaper to reach a settlement on a dispute than to start a blood feud by killing somebody's brother who must kill your sister, etc., etc. So the cost of conflict is very high, and customary law allows non-violent dispute resolution mechanisms to arise. So what are the incentives for somebody to decide to go under the realm of customary law? The biggest incentive is, if you succeed, you will get restitution. Your circumstances will be better after prosecution than they were before, better than before you were, say, robbed or aggrieved in some way. And it avoids the cost of conflict. I don't have to hunt you down and go through the many painful exercises. The great thing about it... Okay, I think the gods are communicating. But it's a good thing when somebody gets robbed and you're a friend of theirs and you can help them recover the goods that were lost, because you are able to fulfill your reciprocal obligation to them. And so you would then have the assurance that if you get robbed at some point in the future, they will feel morally obliged to fulfill their reciprocal obligations to you. It uses persuasion rather than force, and the threats that you have, or the major incentives that you have for this process to work, are the threat of ostracism. Thank you. Okay, thank you. I think, yeah, we're back. So, how do we contrast customary law to its alternative, which is essentially authoritarian law? Authoritarian law, certainly in England, in the West, so to speak, invariably requires the support of a powerful minority. It must be a king or a dictator or a parliament, but it's not generally enforced or put in place by the will of the populace. Even though they may have elected that parliament, they are nevertheless subject to it and the laws that it makes. And it depends on force to maintain social order. It is not a voluntary sort of an environment. It tends to become rapidly arbitrary and rule-bound. It's rules made by individuals or a small group of individuals who are looking out for their own best interests. And that was certainly the experience in England, that every time the king needed to fund a new war, he would basically raise the taxes, create a tax on windows, create a tax on wagon wheels, whatever. It became very arbitrary, rule-bound, and the enforcement was accomplished through the fear of punishment. That was the reason to obey the law, was because if you didn't, you would get punished. And not a lot has changed in the years since then. The key point is that the interests of the state are always paramount in the realm of authoritarian law. Occasionally, the general populace will benefit from this process, but it's the interests of the state that are being served. And in this case, it regulates the interaction between the state and the individual. And the picture is of Edward I, otherwise known as Longshanks, and he introduced a huge amount of authoritarian law into the realm of British law. So, even Voltaire believed that the art of government consists in taking as much money as possible from one party of the citizens to give to the other. And not much has changed in that respect to this day. I think most of us would agree that government focuses more on what it can extract than how effectively and efficiently it can redistribute. And without fail, government institutions of enforcing authoritarian law tend to replace private institutions and customary law. Where can you, well, I suppose to this day there are still privately enforced operations of law, but they're not common. You certainly can't enforce restitution through state law. And the king had a monopoly on the use of force. Now, the primary driver behind this government law, this state law, was, as it always is, due to external conflict. And that is a problem with the logic of this process, is that when external conflict, in this case the Danes arriving on the eastern shore of England, in order to resist them, small local communities had to band together and become much larger communities, and those communities then tended to be run by the local kings. And these kings saw the judicial process, providing law, providing judges, providing judgments. They saw that as a source of revenue, and the kings were always in need of additional revenue. And ordinary crimes and torts were now called violations of the king's peace. When somebody robbed you, it wasn't you that was the victim, it was the king who was the victim, because his peace had been violated, and he was perfectly entitled to subject people to harsh fines, punishments, etc., without any restitution other than to him. So this clash of law systems developed. And as I said, the chief result of 1066, the Norman invasion of England, was the establishment of an exceedingly strong French kingship. They cared little or nothing for the Anglo-Saxon laws and the Anglo-Saxon communities that they were replacing. They established a widespread law enforcement and judicial apparatus to collect their profits from justice. I was interested to note that the term Chancellor of the Exchequer arose from the aristocrats who sat around a table in 1135 and planned how to receive royal revenue and apply incidental justice, and that table happened to be checkered, and that is the origin of the term the Exchequer. And the reasons why we have authoritarian law, why it works so well for them? Well, it imposes the authority of the state on citizens. It tells you who's boss and who's a victim. And from the state's point of view, that's a good thing, and they do it all of the time. Is there anyone in this room who does not feel victimized by the state in some fashion or other? The 11 laws that you have no doubt already broken today. It was obviously a big source of income. It did have the effect of maintaining law and order. I mean, it wasn't entirely bad. The king's law, through the strict fines and the harsh punishments, did ensure that, by and large, crime was held under control, if not eliminated. But it generated fear and obedience in a docile citizenry. And one of the main points of the whole process was to provide revenge rather than rehabilitation or restitution. If somebody stole a loaf of bread, you didn't want to rehabilitate him, you wanted to punish him, you wanted to send him to Australia. It was a matter of revenge. So let's have a look at a couple of interesting historical precedents. And the book starts with this tribe, the Kapauku Papuans of West New Guinea. They're still there. They're famous for one particular characteristic, which we shall see shortly. But they've been around. They were a reasonably large tribe or group of people, amounting to about 45,000 people in 1954, living as very, very primitive farmers. But they had good reciprocal arrangements for support and protection based on kinship within this environment. And they had no formal governmental authority with any coercive power. So when the British arrived and said, "Take me to your leader," they said, "Well, we don't really have one. We a bunch of people here, and some are more important than others, but we don't really have a leader." So the British assumed, well, you're primitive and unstructured, kind of swept away their customs and put in a couple of commissioners and representatives, as they tended to do. But the two basic values of the Kapauku tribe are individualism and physical freedom. And this was well documented and documented at length by Leo Popisel back in 1954. He was doing an anthropological study. He had no particular interest in libertarianism or the law. But as I say, they were and are still to this day famous for one particular characteristic. The men favor very long sexual organs, and they go to all sorts of strange ways in order to promote the length of their sexual organs, continuing to preserve the theory that the guys with the biggest dicks tend to be in charge. But now, in this environment, nobody owns anything in common. There is no sense of the commons. There's no sense of a common grazing area or common fields. Even an 11-year-old, well documented, could own property and money which would be respected by the elders and others in the tribe. But there was, in the absence of leaders, there were people of esteem within the community. And they were called the Tanawi. And this was generally a mature, skilled, wealthy individual, known to be both generous and honest. And the individuals within the community can choose to contract with any of the many Tanawi that were available. And you got a reputation as to whether you were a good Tanawi who settled disputes quickly and cheaply, or whether you were not. And in that fashion, your practice would grow or decline. And his job, by and large, was to adjudicate disputes involving his clients. When they applied sanctions, they varied widely, but they precluded imprisonment because of their respect for individual freedom, torture, or physical harm, unless agreed to by the defendant in preference to the economic sanctions which would otherwise be levied. Now, I found it quite fascinating that this primitive tribe back in 1955 is so far ahead of, for example, the American justice system, that they do not and did not require imprisonment, the use of torture, or physical harm to order their society. If only the Americans could get to that position, or us, for that matter. And once again, the techniques they used, ostracism, public reprimand, one we haven't thought of applying here, sorcery, and exile, were other punishments that they might well apply. Sorcery might be an interesting alternative. The interesting thing is that an individual could be subject to several legal systems simultaneously. And the laws were based on his kinship. So he may be a member of that tribe over here, but his wife is a member of that tribe. And if he beats up on his wife, then he'll be judged by that tribe's laws. His cattle may wander into a third tribe's area, then in which case he would be judged. So they had a quite sophisticated system of jurisdiction. And I think it's time to question the assumption that justice is best supplied by government. With our current justice system, and I doubt anybody will disagree, there's a massive underreporting of crimes because there is no benefit particularly to the victim in reporting a crime other than to stop the crime in immediate progress. But why report a crime if you're not going to get any restitution out of it? The only real motivation is revenge against the person who had the effrontery to rob you, let's say. But the net result of that is, within our system, many, many crimes go unreported. I would presume that every person in this room has had crimes committed against them that they could not be bothered to report to the local police. The whole system has massive delays. It's hugely expensive. Certainly in an American case, and I think it would be true to say here, that you get inferior convictions due to plea bargains. In other words, somebody who is clearly guilty but it's going to be difficult to prosecute in court. We give a plea bargain to, and somebody is guilty of a serious crime, say rape, plea bargains down to a lesser charge of assault in our current system, and goes away for 2 years when he really was guilty of a crime worthy of 10 years. Now, according to Benson in the United States, certainly in 1990, something like 75 to 80% of all crimes in the United States convictions were obtained via plea bargains. So it's a system widely used. Of course, it supplies no restitution for the victim. It utilizes inadequate and awful punishment systems we should be embarrassed and reluctant to use at the beginning of the 21st century. And of course, as we know, the whole system is subject to widespread extortion and corruption. And this brings us to the issue of how are you going to enforce the law within a customary law system? I don't know how many of you know that state law enforcement is relatively recent. It's really, I think, came into effect in the West in the 19th century in the face of much opposition. The locals, certainly in England, correctly predicted that this will lead to a police state. This will lead to widespread abuse of powers by new gangs which are called the Bow Street Runners or something along those lines. So public police forces haven't been as widespread or necessary as we thought. Well into the 19th century, law was enforced by the victims chasing down the criminals. And to this day, private security forces in the United States still outnumber state police 2-1. And I believe in South Africa, private security forces outnumber the state police 3-1. So there is an existing infrastructure to provide justice, or law enforcement rather, in the absence of the state. Prosecution is interesting. Crime victims acted as prosecutors until nearly 1900. That was something I was not aware of, that when you went to court right up until the early 1900s, the victim would stand up in court and plead the case before the judge, not using necessarily a lawyer. And 75% of commercial disputes to this day are settled outside the courts. The biggest point, though, is that victory in court benefits the state, but it does not really benefit the victim in any way other than the gratuitous revenge that you might feel as the prisoner is led away in chains. And in South Africa, we have pathetic conviction rates anyway. But nevertheless, let's ask the question. The judiciary is one of the few widely respected state institutions still. It's got a long and thoughtful history. There are many wonderful judgments written, many precedents over the years. Many would agree that it's critical to peace and stability within our society. It's largely a non-violent system. You don't tend to get tortured and beaten up in court. And it's a non-controversial function of government, by and large. And as we have observed in South Africa, it is pretty much the last bastion of reason and fairness in a system pretty much overrun at this stage by aggressive politics. So if it ain't broke, why fix it? Because it has many problems as well, and we're all well aware of them. It's extremely expensive. It excludes, by and large, poor people and, in most cases, middle-class people as well. It's inaccessible. How many of you would know how to file a claim in a local court without a lawyer? Difficult process. It's compromised. There are dishonest judges. There are dishonest court officials out in there. It's slow. It's inefficient. It's obligatory, not voluntary. You don't get to choose if the police capture a criminal that has robbed you, you don't get to choose whether you prosecute him in court. The state makes that decision on your behalf. It's old-fashioned, and it's not just because they wear funny wigs. It's not market-driven. That should be the biggest sin as far as a libertarian is concerned. And it basically operates off the wrong incentives. Imprisonment under the current system is ineffective in rehabilitating criminals. We can all agree on that. It encourages future crime. It's exorbitantly expensive, forcing in general the victim to pay twice, once for the loss that he never gets any restitution from, and thereafter the taxes to maintain the criminal in a prison system. It ruins the life of many petty offenders, and it provides revenge rather than restitution. Are we really not clever enough to come up with a better system that a bunch of savages in the jungles of New Guinea seem to nail for themselves? Now, for many years, I've sat in these libertarian seminars and I've heard the term tort being used, and whenever it came up, I never knew what they were talking about. It's just not one of those words that sort of filters through into common language for me anyway. So, I'm defining it. A tort is an offense against an individual, whereas a crime is an offense against the state or society. And I can remember Leon many years ago saying that we can do away completely with criminal law. All we really require is tort law. It doesn't matter whether the state feels aggrieved by some action you take against it. The tort requires a harmful action against an individual, whereas a crime is whatever the authority deems unacceptable, whether the crime is victimless or not. Now, one of the best examples of this is a concept called the law, and I think it's pronounced merchant. Do any of the lawyers want to correct me on that? Is it called the law merchant? How many people have ever heard of the law merchant? Let's call it that. How many people have heard of the law merchant? 2 lawyers, 3 lawyers maybe? Not a widely known concept, and yet it demonstrates what I am saying almost perfectly. Okay? It shatters the myth that government must define and enforce the rules of the game. It developed completely outside the constraints of political boundaries. It is a system of law that applied all across Europe, across England, and out into the colonies themselves. It provides the best example of what a system of customary law, and it is based on customary law, which means that the law is developed by the people who are subject to it and who used it. It's a classic example, and it ran from about the 11th century until about the 19th, maybe even the early 20th century, where it was replaced by a system of laws where they codified all the general agreements within merchant law and turned it into 21 commercial laws. It is still to this day, by and large, the basis of commercial law. And it governed every aspect of commercial transactions in all of Europe. It was an incredibly effective and efficient system. And it arose through free trade and commerce. Basically, traders would move from one fair to another around the country, attempting to sell their goods, obviously at the best price and as quickly as they could. But often a dispute would arise of some sort and the other. But these merchants would only be in town for a day or two. They would be there for market day, and then they would have to get on their horses and wagons and move off quickly to the next town or suffer significant losses. So they required a system of law that would sit and adjudicate a dispute between 2 merchants immediately, and would use a common set of laws to adjudicate that dispute. And that is what the law merchant was, and that's how it arose. And the whole purpose of it was that agreement, not conflict, was the overriding force in regulating business conduct. You would come to some arrangement with the aggrieved party. They had no authority and no position to enforce anything. So the law merchant required you to come to an agreement. It would just help arbitrate and settle that dispute. And it did not consist of statutory codes, but basically written commercial instruments and contracts, which would then over time become standardized and codified. This is the contract for corn, this is the contract for transport, etc., etc. The standard contracts would arise, and they would be effectively the contents of the law merchant. Its features: voluntary cooperation, contract-based, it's objective, fair, and impartial, because the people who actually use that law are the ones who make it. The obligation to obey arose from the recognition of mutual benefits. Sure, I might feel aggrieved that the law had decided against me in this town, but when I moved on to the next town, it decided in my favor. You would recognize that there was mutual benefits in having a law like this. Operated completely without the coercive authority of the state. The law merchant was so successful that the state felt it could not interfere in it without seriously disrupting trade. So they pretty much left it alone. And the courts, the key thing was that they were, by and large, run by other businessmen. They were knowledgeable, fast, and informal. They could reach decisions very quickly. Let's have a look at the rise of lawyers within our court system. The rise of a class of professional legal advisors has been resisted due to several ancient principles. One of them was that in a court, an unskilled defendant being cross-examined by the victim of the crime were less likely to be successfully conceal their guilt behind honeyed words and lengthy legal phrases. If you were guilty, it would probably show in your behavior. So there was an advantage to being to the law system to have unskilled defendants not defended by lawyers. And without skilled pleaders, neither party in court had an unfair advantage. So if you went up against a lawyer, well-known, widely skilled, and you couldn't afford as good a lawyer, there's a strong chance that you will lose purely on the basis of the difference in skills between the lawyers available. But as with most legal developments, the legal profession was developed to give special advantage to the king. So they really arose as a class of people who would handle the pleadings of the king in the various courts and ensure that the king himself always succeeded in one of the effects is that legal procedure became much more complex. And we've all seen the vast extent to which law has grown, the many law books on the back of every lawyer's office. Justice was prolonged endlessly. If you have a system where people are paid by the hour, there's a huge incentive to make the system run for as long as possible. Believe me, I know, I have been a consultant. Lawyers, rather than clerics, became the primary candidates for judges. So previously, basically the judges in a community, even under authoritarian law, were selected from the clergy because they were good, honest people without ulterior motives. But that changed over time, and lawyers were now selected as judges with a negative effect on ethics. So, in summary, customary law is primitive. Customary law is concerned with the protection of individuals and their property. And that sits very well indeed with the libertarian ethos. There is no external police force. Claimants use their kin groups to pursue defendants. Cases would be generally judged by local elders dependent on popular support rather than by imposition from a superior force. Most claims were settled by restitution. Interestingly enough, I think amongst the Kapauku, they had a long and complicated menu of costs for the various crimes that may exist. So raping your wife had this price, raping a friend's wife had that price, raping a little girl had a third price, stealing a cow had this price. They tended to become codified, and fairly quickly Tanawi would say, right, you're guilty, that's going to cost you 500 clams. And if you didn't pay up, you would be ostracized or outlawed. Interestingly enough, in many of these societies, these customary law societies, prison was not considered an appropriate punishment. Even within our own society, within our black customary law, as far as I know, they have no provision really for imprisoning criminals. So authoritarian law was a means to fund the king. It replaced restitution with fines and many cruel and unusual punishments, confiscations, and often capital punishment. Excuse me. It's an imposed order instead of a spontaneous order, and it has all the consequent problems. Basically, authoritarian law collectivizes the law in favor of the state. So how would a private system of law operate? Do we have to have a social contract and a constitution in order to have a just society? Well, it emerges spontaneously, and reciprocity provides the basis of compliance. Key point there is that individual cooperation does not necessarily require collective action. I think that's a point we could make across South Africa, we could make it to the ANC and many others. Not everything has to be accomplished through collective action. Individual cooperation can do a great deal of good. If you want to have a look at a customary, spontaneously arising law, if you just simply have a look at your tags, some of you have little dots on your tags which indicate whether you're a vegetarian or not, whether you're entitled to eat on this day or that day or not. This was a customary law which I simply created at my desk as a means of organizing the behavior at the conference. And by and large, nobody objected, so the law applied. I haven't had to punish anybody, as far as I know, for not enforcing our colored dot system. I'd like to just read that out, because you can never go wrong quoting Hayek at a libertarian conference. So he said, individual freedom, wherever it has existed, has been largely the product of a prevailing respect for such principles which have never been fully articulated in constitutional documents. Individual freedom. It's been preserved for prolonged periods because such principles, vaguely and dimly perceived, have governed public opinion. I won't even try to elaborate on his wisdom. So without government enforcement of law, man's only duty is to respect others' rights. That is a duty that we are all subject to. And your only right over others is to enforce that duty. That is the only time you get a right to exercise force, to aggress against your neighbor, is when enforcing that duty. There would be no criminal law, only torts, offenses against victims, not the state. And many crimes would still be illegal, of course. The whole pantheon of crimes that we have defined, if victims are involved. But you would probably find that under this system, victimless crimes, from which you cannot extract any particular restitution, would find few paying enforcers. Victimless crimes would basically fall away automatically. Who pays? Well, individuals. You don't get anything for free. One of the great contradictions of our current system is that the state offers you law enforcement, it offers you a judiciary, it offers you imprisonment systems essentially for free, thereby completely subverting the free market. You cannot get a better police station response by offering to pay another police station more money. The system does not allow for that. You cannot get a better judge to adjudicate your case by being willing to invest more money. You get whoever is randomly assigned by the state. Simple economics will ensure that cooperative systems arise amongst competing agencies. This has been an endless debate. I seem to remember in Anarchy, State, and Utopia, the conclusion was that these competing systems would invariably lead to one dominant system that would destroy the rest. I would dispute that, and there is some historic precedence to say that does not arise. Yeah. Apprehension. When an offense is committed, the victim seeks restitution. He appeals to his family and kin group. Punishment will typically be a fine sufficient to leave the victim in a better state than before the crime. You look forward to the next time you get robbed. You look forward to the next time you get beaten up, because it's going to make you so much richer than you were. And this provides the main incentive for action against offenders. We'd have private courts, contractual arrangements. The law merchant is a good example of how this can be done. You'd get reputable judges. The court cases may become high television, significant entertainment. Judge Judy is a classic example. And in most cases, private security and private arbitration will seek to avoid conflict because it's so expensive. Are we done? Yeah, I'm on. So, where's it worked? Anglo-Saxons from the 5th to the 11th century, medieval Ireland, medieval Iceland, law merchant, Seer law in Somalia, I have spoken about that in the past, the Kapaku tribe, traditional African law. The early Hebrews lived under a form of customary law. There's even a form of customary law in Germany and Westphalia. And currently, widespread use of mediation in our society, widespread private settlement. On the internet, there are many private settlement agencies. In fact, I don't think there is any enforcement agency with any real teeth. And with a bit of luck, we might even run such a system in Clancy. One of the reasons perhaps for putting this talk together as a proposal to the several secession groups who are thinking about what systems of law would they operate under. Well, here's an alternative to consider: customary law. So in conclusion, I believe the state may supply many, many laws, and it does. And it may impose its own form of order and regulation, and it does. But do not seek liberty or prosperity or security or justice from the state. That's it.
Because of time constraints, I will allow 5 questions, but please keep it short as possible, because we have one more speaker and we need to finish 6 o'clock. Because, by the way, please take all your goodies. Remember, they can put the tables in different format. There's people from town coming for the concert, etc., etc. So we need to be out of here 6 o'clock so they can put everything down. And please take all your goodies, leave nothing except
Can I add to that very quickly? Please take your programs with you. Please use them to rank the speakers so far. You will be asked to hand them in tomorrow morning.
Trevor.
Where'd that go? Oh, there you are. Right.
Question 1. I've actually got 2 questions, if you don't mind. The first one, you mentioned that the cost of conflict would incentivize peaceful dispute resolution. If you look at the rise of the taxi industry, which arose in a purely free market environment, it was illegal initially. It was totally deregulated in 1987. Taxi associations formed. Taxi operators pay protection money to the taxi associations. They claim rights that they don't have, like monopolies on routes, and they will defend those rights with AK-47s. This has been happening since the late 80s. Initially, there was a political element to the violence. After 94, there really wasn't. The violence remained competitive. over routes which they don't actually have monopolies over. And that carries on to this day. Right? They act like mafia organizations, they operate like protection rackets, and they will shoot rivals, and routinely do so. How does that show that customary law would actually develop and peaceful resolution mechanisms would actually develop?
Well, the famous excuse is let me answer. My memory doesn't extend to two. That wasn't real socialism. That wasn't real customary law. Of course that will happen. Mafias do arise. Mafias generally arise as a means of protection of, for example, Italian immigrant groups. And they do insist on payment. Okay, so you do pay the mafia or serious consequences.
And they burn your place if you don't pay.
Sorry?
And they burn your place if you don't pay.
Yeah. Not a perfect system, but the mafia, by and large now, is a completely legal operation in most of its jurisdictions. It evolves over time, particularly in the case where there's a conflict between the state law and the private and customary law. But do you really think that the taxi associations would not prefer a better, less conflict-ridden system that they could operate within? And I suspect that they will aspire to that, and that the fact that the taxi systems do continue to work reasonably well, we do have widespread taxi systems, say that for all of its faults, there is a system in place there that is very poorly policed by statutory law at this point in time.
Good. Conversely, you said that the rise of authoritarian law happened in an environment that was previously dominated by customary law. You explained Alfred the Great, had to react to the Danes. If you re-establish customary law somewhere, why wouldn't exactly the same threat and the same needs, the need for a public fiscus to conduct war, once again gives rise to authoritarian law?
As I said, that is the weakness in the system. It probably will always be the problem until we can settle the issue of strong external forces invading. You're probably going to have to rely on gathering under kings and states. That is the unsolved problem. The unsolved problem is not how to administer the law, it's how to resist invasion.
I think we should take heart. I think customary law is in fact potentially alive and well in South Africa. I live very near a small town called Elands Bay, which is rated as the poorest town in South Africa. And recently, a guy who works with me, his wife lives in the township, and some squallies moved in, and they came and they raided and robbed the local spaza shop, the local little container shop. This man's wife got all the kids together, and they watched these guys, and they followed them. They followed them about a kilometer down the road. They didn't allow them to take their cars, which they came up from somewhere else. They followed them to a deserted school, and they went to them and started shouting at them and saying, "You must come back. You must come back and pay for this." And the guys ran away, and they ran to a local farm another few kilometers away, and all these kids and this girl, this lady, followed them. By the time they were following, there were about 20 people there. We went past in the car and didn't know what was happening, and we heard about this afterwards. They eventually cornered them at this local farmer's place, and the local farmer's guy said, "Come on, this is no good." The police refused to go because there was two of them and there was two policemen, so they didn't want to challenge them. Eventually, the farmer phoned the police and he said, "You have to come." So eventually the police did come. So the means to justice was done eventually by the police, but catching them was with the people themselves.
If I could say, comment, I think customary law is very common. It's probably provides maybe 60 or 70% of the law enforcement in this country at this point in time. Let's face it, if your neighbor pinches something from you, how many of you are going to phone the police as your first reaction, as opposed to your security agency, or calling upon your friends to go around and get the stuff back, etc.? The police do have a function, and they do operate, but a huge amount of our effective law enforcement is customary to this day, within white communities as much as others. So, right, next question.
Is the current mob justice in the townships a good example of customary law, spontaneous?
Sorry, I can't see who asked that. Right. No, it's an example of anarchist behavior. It's illegal, riotous. These guys are destroying property. They offending against other people's rights. Why do you think it stopped? Okay, I think it stopped because the local community said, enough of this. Okay, just enough of this. I think enough people went and had a chat to the offenders. I do not believe that the police have the capability to even go into a township like this now and find the offenders and settle the dispute. I am pretty sure that the community itself resolved these crime issues.
Now, for example, when the community finds a child molester and then they tear him to pieces, is this a good or a bad thing?
Well, you must always be responsible for the actions you take. So if a community does that, that is wrong, that is a crime. And one would hope that the people who do that within the community will also be pursued by other people within the community. I think the vast majority of communities would rather live in peace under a reasonable system of law than impose vigilante justice. But sure, vigilante justice does happen. Crimes do happen. They always will. They must always be treated as crimes. You must always follow up on them. As to whether a defense agency, for example, an ADT or something like that, would be a better system than the local police. I mean, here's a simple question. How many of you have a private security agency looking after your interests? Okay, so don't talk to me about your belief in police enforcement systems.
Okay, thank you. We really need to move on to the next speaker, please. I know there's some questions. We'll try to see if we can...
Oh, okay, yeah.
Can we take this in?
Sorry? I do have a system that generates random numbers just like the police system.